A person at the Wexford County Jail, please state your name for the record.
Charles Stewart.
All right, this is case number 255092 OD, the people of the city of Cadillac versus Charles Edwin Stewart. Mr. Stewart, you are here for a bond violation. It's alleged that you failed to enroll in alcohol and drug testing as ordered on December 15th, 2025. You do have the right to have a contested hearing in this matter, where the prosecutor would have to prove to the court that you did in fact violate your bond by failing to enroll. Mr. Harrison, how does your client wish to proceed today?
At this juncture, we would enter a not guilty plea and set it for a hearing. I say that somewhat reluctantly, Your Honor. I've been forced to restart my computer and it's updating, so I can't give you any more details at this juncture, but if you'll give it.
Do you want a moment?
The 20 or so minutes it'll take to update.
Oh, it's gonna be that long, huh? All right, we will set the matter for a contested hearing. Mr. Stewart was originally arraigned on this case back on the 15th of December.
Okay.
With PR bond and drug and alcohol testing, and to enroll with Community Correction Services.
Is the allegation that he simply didn't enroll?
That he did not enroll.
Did not enroll.
So a bench warrant was issued, and here we are today. Comment regarding bond, Mr. Harrison?
I would only say this, Your Honor, due to the time of the year it is and the fact that we have a jumbled up schedule. It will not likely be a couple of days before we can get this resolved. It'll be more like a week or 10 days. In light of that, I would highly recommend that the court release the PR again. And perhaps on this occasion, if he does elect to enroll with testing or clear up whatever the issue is, perhaps the whole thing can just go away.
Thank you. Ms. Lawrence?
Your Honor, I am tempted to ask for a remand for the time being. The defendant has been on bond for roughly 2 weeks now and has still not enrolled in testing as directed. Given the underlying charges, operating while intoxicated, that does cause quite a bit of concern for the people that he has not been testing for the last 2 weeks, and given the holidays coming up, I don't know if I necessarily trust that he is going to follow the direction of the court. So for the time being, I would ask for a remand.
Thank you.
Okay.
Well, as I said, the defendant was placed on bond with personal presence bond back on the 15th. It looks like court signed the warrant in this matter on the 19th and it was picked up the 26th. So he had not tested as he was supposed to for almost 2 weeks, as Ms. Lawrence states. So we will remand until we have a hearing. Next arraignment.
Jeremy Powell.
This is case number 255159 FY, the people of the state of Michigan versus Jeremy Joe Powell. Sir, you met with somebody from Community Corrections today and gave them some contact information. Is that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the Defender's Office today?
From where?
The Defender's Office?
Yes, sir.
I have a complaint that alleges that on or about December 27th, 2025 in Springville Township of Wexford County, it is alleged in count number 1 that you committed the offense of possession of methamphetamine. That is a felony punishable by up to 10 years and or a fine of $15,000. In count number 2, it's alleged that you committed the offense of possession of a narcotic less than 25 grams. That is a felony punishable by up to 4 years in prison and or a fine of $25,000. Do you understand those charges and the potential penalties?
Yeah. Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I want to hire an attorney, sir.
I'm sorry,
I want to hire an attorney.
you're gonna hire your own attorney?
Yes, sir.
You have the financial means to do that?
Yes, sir.
All right. The court will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'll be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, I show in 01 a driving license suspended, 04 NSF check less than 100. In 05, there was an NSF 100 to 500 set aside. There was a virtual records violation in 05 that's been set aside. In driving the license suspended, second was set aside, and another driving the license suspended was set aside. In the local record, not as CCH, there's a plate violation from 2000, driving the license suspended from 01, an unlawful plate from 04, driving the license suspended from 06. There's a wildlife general violation in 15, set a fire without reasonable precautions, 20 unlawful plate, 94 shining with a bow or firearm, and in 94 failed to display a license. Mr. Harrison, I know he's indicated that he plans to hire an attorney, but do you have any comment regarding bond? The praxis does score him at a risk level 1.
Indeed, yeah, I'm aware of that as well, Your Honor. In light of that, any concerns the court may have with regard to him possessing or using could be easily allayed through testing. He's a good candidate for PR. He's local. He's been a member of the music community for a number of years. He's employed full-time. He runs his own business for tree removal. I imagine he'll be able to get quite a amount of work done in the next week or so after this latest bout of weather. I don't see any reason to keep him incarcerated at this point. He doesn't appear to be a flight risk. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. This started out as a traffic stop for crossing the center line. Eventually, a clear glass pipe that was filled with methamphetamine, as well as one bundle of cocaine, was found on the defendant's person. I do understand he has a very limited criminal history, but given the seriousness of the charges, I am still going to ask for a $5,000 cash surety bond. And I would also ask the court to impose random drug testing.
Thank you. All right, Mr. Powell, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. I am going to release the defendant on a personal recognizance bond. This does appear to be a first drug violation, at least as he has no prior convictions. Mr. Powell, at some point today, you're going to be released. When you are released, the courthouse is probably going to be closed, so you need to make sure that you present yourself tomorrow to get signed up for testing. Do you understand that?
Yes, sir.
By not doing that, there'll be a violation of the court's order. You could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, sir.
All right. Next arraignment. Please state your name for the record.
Becky Lee Hart.
Thank you. This is case number 254847 SM, the people of the state of Michigan versus Becky Lee Hart. Ms. Harp, you are here for an arraignment on an alleged bond violation. In particular, it alleges that you failed to take, get to the right page here. You failed to take daily alcohol tests as ordered on December 19th and December 21st. that you failed to report weekly and failed to contact Community Corrections Office, that you currently owe Community Corrections $270, and that you failed to take an ETG test as directed on November 20th, November 21st, November 23rd, November 28th, December 11th, December 12th, December 14th, December 15th, December 16th, December 19th, and December 21st. If you are found to be in violation of your bond, your bond could be revoked. You also have the right to have a contested hearing in this matter, where the prosecutor would have to prove to the court that you did in fact violate your bond conditions. Mr. Harrison, I know this is Mr. Hartel's case. Have you had the opportunity to meet with Ms. Hart?
I have not. I don't know if he did either. He did make the rounds this morning via Zoom.
How are we proceeding today?
Well, at this point, we would have it set for a hearing. Again, I realize that there are multiple allegations here and that the proofs are minimal. I'd just like to know more about the intention of the community corrections as well.
All right. Court will set the matter for contested hearing. Defendant was arraigned back on the 17th of November with conditions, standard conditions, and should be placed on daily alcohol testing, along with no contacts and no weapons, firearms, or threatening, intimidating, harassing behavior. Comment regarding bond, Mr. Harrison?
Other than the fact that she is a member of the community and it does not appear to be a flight risk despite her apparent lack of attention to her bond requirements, I can't think of a reason why I believe that remand is appropriate here. I would recommend the court reinstate bond release pending the hearing.
Ms. Lawrence?
I am going to ask for remand. I think it's pretty clear based on just the amount of alleged violations. She clearly has not been following the rules. She has not been testing. She has not been keeping in contact with community corrections. And I think this clearly shows that she's not a very good candidate for supervision, at least at this time. So I would ask for a remand pending the hearing. Thank you.
The allegations in this case are domestic violence. The defendant does have some alcohol-related convictions in the past, but those have been set aside. However, given the sheer number of alleged violations in this case, all dealing with testing for alcohol, the court is going to remand. Gail, next to Raymond.